Hello, everyone. The Collegium system of the Supreme Court is back in focus in the light of certain reports that there is some kind of a split among the Supreme Court judges regarding certain proposals for elevation. Now, these are all unverified reports based on certain undisclosed sources. The problem is that we don't have any clear or transparent mechanism to secure reliable information regarding the workings of the Collegium system. The biggest criticism against the Collegium system since the very beginning has been its secrecy. So this gives rise to a lot of speculations and rumors and hearsays, which all together puts the entire selection process under a cloud. So in this context, we are joined by former Supreme Court Judge Justice Madan B. Lokur, who has been championing the cause of transparency in judicial appointments. So let's listen to his views regarding these developments. Welcome, sir. Thank you so much for joining us today.
Thank you, Manu.
Thank you so much, sir. So what are your views regarding these developments, which suggest some kind of a stalemate within the Collegium system?
Yes, but like you said, these are unverified reports and they're undisclosed sources. So really one can't be 100% sure about what is happening. But I think, the newspaper reports that have been coming in the recent past seem to suggest that some names were suggested or recommended by the Chief Justice to the Collegium. And those names have been disclosed. That's there in the newspapers. But there seems to be some kind of a problem. It also appears, again, one can't be sure about it. It also appears that one of the objections is that the procedure that is being followed of, circulating those names through a letter has not been, taken kindly by two of the judges. But there does not seem to be any dispute about the names, about the persons who have been recommended. Again, one can't be 100% sure about this, but it appears that there does not seem to be any controversy about the names. So really, if you look at it from that point of view, if there is no controversy, there is no dispute about the names, assuming it is so, then whatever method is followed, should not make much of a difference, because it does again appear that these names were discussed earlier and were accepted by everybody. So it's just unfortunate that, a physical meeting could not take place where they could have met and finalized these names. So I suppose the Chief Justice took the second best option.
So, sir, regarding the judicial selection process, so the rule which has been followed is that unless there is complete unanimity among the judges, the names won't be approved. And if there is some kind of a dissent, even by a single judge, the names won't be recommended. I believe that has been the process which is followed. So within the meeting itself, so there is a venue for any judge to voice his dissent, right, sir? And we have certain instances, like, for example, Justice Chalameshwar, there was an incident of Justice Chalameshwar refusing to attend Collegium meetings. So how do you see? How do you think the deliberations should take place? And
yeah, you see, ideally, the deliberations should take place physically. There is a room in which the judges meet, the judges of the Collegium meet. So ideally, that should happen. But like I said, we really don't know what's going on. Is there a dispute about the names? Right? So now, when you say that, some judges have dissented or one judge has dissented, but has that judge or those two judges dissented with regard to the names or have they dissented with regard to the procedure? We don't know. So if there is no dissent with regard to the names, then it's a 5-0 situation, right? But if there's a disagreement, not a dissent, but a disagreement with regard to the procedure, then it's a different story altogether. Then there is, if it's only about the procedure, then there's no dissent about the names.
Mm-hmm.
So really, everybody's kind of groping in the dark, about what's happening, right? That's why I think, there is a need for transparency in the, procedure and in the process that is being followed.
You have rightly put it, sir. We are groping in the dark because since there is no transparent mechanism, we are all forced to speculate and rely on hearsays and rumors. So you have been very vocal about having a transparent system for judicial appointments. So to what extent there should be transparency? So do you think that the entire deliberation process should be open to public and public should be able to access that? Or do you think that there should be some degree of secrecy attached to the deliberation process, but the reasons for selecting someone, that should be disclosed, or reasons for not selecting someone, that should be disclosed? To what extent you would advocate transparency?
Yeah, I'm not suggesting that, the deliberations of the Collegium should be open to the public. I'm not suggesting that at all, but the people should know who are being considered or who are being, who are recommended. Of course, that comes out in the open when the Chief Justice sends the recommendation to the government. But who are the persons who are being considered? Now, look at it from the point of view of the High Court, right? Now, when the High Court Collegium sends the names, when the Chief Justice of the High Court sends his recommendations to the Chief Justice of India and to the Chief Minister, Governor, and Law Minister, the names are known to the bar. All right, everybody in the bar knows it. I mean, it's an open secret. Okay, so everybody knows that these are the persons who are being considered, and then later on, the process, is followed. Which is to say that there is scrutiny by the Intelligence Bureau, there is scrutiny by the Law Ministry, there is scrutiny by the Supreme Court Collegium, and then the names are accepted or not accepted or deferred, and then the warrants of appointment are issued in respect of some of them or all of them. So there is no secrecy attached to the recommendations made by the Chief Justice of the High Court. Formally, there is a secrecy attached. But the fact of the matter is that everybody in the High Court knows who are the persons whose names have been recommended. That's a fact that we have to accept. If that is so, then I don't see why those names cannot be disclosed as far as the Supreme Court appointments are concerned. All right, because it is another system of appointment. It's not that we are considering 20 people and these are the 5 who've been shortlisted kind of thing. But yeah, this is the shortlist. Now, in the present case, assuming the newspaper reports are correct, the names of these 4 persons are known. Right? So where is the secrecy? If the idea was that the names of persons who are being considered or who are likely to be recommended should not be known, then how come the names of these 4 persons came out in the newspapers so that everybody could read it? So what is the level of secrecy that you're looking at? What is the level of transparency that you're looking at? All right. There has to be this balance, and I would tilt the balance slightly in favor of transparency. Okay, it doesn't do any harm. All right. Now, the second aspect of your question is with regard to persons not being recommended. Should the reasons be given? I don't think reasons should be given. That's a matter of privacy that is involved. That's a matter of the reputation of the person involved. There could be a variety of factors why a person has not been recommended. But when you have two people who are outstanding, why have you selected one and not the other? The reason for selecting, should be made known. Now, that can only be made known if there is some criteria that is laid down. And there is no criteria that is laid down. The only criteria is that of age. And in the case of High Court, that criteria is also in the of income, right? But there's no other criteria for the High Court judges, nor is there any criteria for the Supreme Court judges. So it's all right to say that, yes, we are selecting the best. Of course, you're selecting the best. But what about those who are better than the best? What is the reason for not selecting those who are better than the best? And we've had instances in the past. Akhil Qureshi is one example. How come he wasn't selected? Presently, you have one judge, I would not like to name him, but not selected. Why? So that is an area, I think, where we need to know, where the people need to know, particularly those in the legal fraternity, that why are those who are better than the best not being recommended?
So it means that if somebody is overlooked, and for example their seniority or their merit is overlooked and someone else is appointed, it can give rise to a speculation that there are certain extraneous reasons for that.
Yeah, well, again, you have rumors, Oh, and speculation. Oh, this fellow has been overlooked because of this.
Right.
Right. Now, that's not good for the system. You have these rumors floating around. It's not good.
For example, in the case of Justice Qureshi, it was since he was overlooked, there was the speculation was that since he has taken certain judicial stance against the establishment, against the executive, that could be the reason. So this gives rise to a lot of unnecessary speculation as well. That's what you're suggesting, right?
Yes. And this can be avoided. If we are told that, well, Qureshi is outstanding, but we think that somebody else is better. And why do we think that somebody else is better? This is the reason why we think somebody else is better. So you keep the reputation of that person intact so that there are no rumors, but you give a reason why you have selected somebody else. Criteria is important. I think the time has come for the Supreme Court to sit down, deliberate, and decide the criteria. In England, they have published the criteria. We haven't published the criteria. And now with this, these controversies coming up, I think we need to have a rethink and, publish a criteria so that, these rumors, speculations don't arise at all. It's not good for the institution.
What all criteria you would suggest, a broad criteria based on your experience as well as your exposure to international judicial systems?
Yeah, well, the performance of the person, right, as a judge. There are two things, that are involved. One is the judicial performance and second is the administrative performance. You have committees in every High Court and also in the Supreme Court. All right. Now, a judge, depending upon the seniority, which, happens, may become the chairperson of NALSA, for example, right? or may become the chairperson of the Supreme Court Legal Services Committee, or may be involved with the National Judicial Academy. Okay. Or may be involved in some other projects. For example, I was involved with the e-courts project. I was involved with the juvenile justice, management. I was involved with the mediation committee. All right. So now a person who lacks administrative skills, if he's made chairperson of NALSA or if he's made chairperson of some other committee, it won't help that committee. It will not help that organization or that institution. So I think administrative work should be taken into consideration plus judicial work. What is the criteria that should be laid down for both? I think is really for the Supreme Court to decide. Because even a junior judge, a relatively junior judge, can be asked to perform administrative functions. For example, when I was appointed to the e-courts committee, I was the junior most judge in the Supreme Court. But the Chief Justice had faith in me and said, all right, you manage it. So both these things have to be taken into consideration.
So right now, the Collegium system, it follows some kind of an ad hoc mechanism under different Chief Justices. That's what you're saying. There is no objective criteria as such.
Yeah, there is no, there is no criteria, you can say objective, or any other criteria. I mean, there has been talk in the past, of a performance audit, right? When you're taking a judge from the district court to the high court. All right, what kind of a performance audit do you have? How about a performance audit for a judge from the High Court or a Chief Justice from the High Court to come to the Supreme Court? You could have a situation where a person, a Chief Justice, for example, is administratively weak. You can still bring him to the Supreme Court. There's no difficulty about it. But then make sure that you don't give him any administrative assignments. Because you know that he's not a good administrator. So, all this actually should be, in my view, should be taken into consideration.
So for the Collegium system, as I was mentioning earlier, under different Chief Justices, it has taken different measures. For example, during the tenure of CJI Deepak Misra, there was the system of publishing the reasons that was started, but later it was continued. And later during the term of CJI Gogoi, there was this practice of interviewing the recommendees, but it appears that later it was discontinued. So do you think, should there be a set procedure for which can be uniformly followed, or should it be flexible so as to be modified as per the different needs and circumstances?
Yeah, there should be a set procedure. But let me also say that, the interviews that you were mentioning about when Justice Gogoi was the Chief Justice, they were not interviews. That was for the purposes of knowing who is the person. I mean, you've got to see his face at least, to know. I mean, you just can't decide on the basis of papers. So have a chat, with that person, see who he is. If there is something, about that person which has come out, either by way of a complaint somewhere or the other, or in the IB report, put it to that person that, this is what is being said about you. I mean, do you have anything to say? Right? And then he gives an answer, and, then you take a call. So it's not an interview in that sense, but it's like a sort of a chat with the person, to know that person, to know who are we recommending. right? And in spite of any adverse comment that may or may not be there, if there is an adverse comment, well, we've heard him, we've accepted his explanation. There are things that people may want to say. A person who is being recommended for the High Court may want to say something and express some view to the, Collegium. Why not? So it's not an interview. Okay, but yes, in the context, and by the way, I was told that this system was discontinued, at least this is what I'm given to understand, was because of COVID. The person could not come to meet the Collegium. But yes, you're right. Some criteria has to be laid down, some procedure has to be laid down. It can't be watertight, but there must be some, procedure with some degree of flexibility, some criteria with some degree of flexibility. For example, when you talk about the income criteria, the fee that a lawyer earns in Delhi is much more than the fee that a lawyer will earn in Nagaland or in Manipur or in Meghalaya. So that flexibility has to be there. You can't say, oh, you're not earning as much as a lawyer in Delhi, or you're not earning the minimum that we have prescribed. So therefore, we will not consider you. If that is the position, then very few people from the Northeast will ever be appointed. Except from Assam, maybe, but certainly not from the other 6 states and from Sikkim, maybe even from Jammu and Kashmir, maybe even from Chhattisgarh, maybe even from Jharkhand. One doesn't know. So there has to be this flexibility.
Right. So now moving on to another issue. So once the Collegium recommendations are made, it is up to the union government to accept it or not accept it. So one trend which has been noticed in the recent past is this practice of pick and choose followed by the executive. For example, some names are immediately notified, but some names are not notified, and they are kept pending. So do you think that this gives rise to a lot of interference by the executive, so that they can get to choose their own people who are favorable to them, and people who are perceived to be unfavorable, their names are kept pending?
Yeah, again, rumors, speculation. Why is the government taking so much of time? Why are they picking up some and not picking up the others? Is there some kind of favoritism? Is there some kind of nepotism? Why is all this such a big secret? You had cases right here in Delhi, where names have been sent. 2 people were picked up, other 6 were not picked up, and two of them were appointed. Then after that, I think another 4 were appointed, and 2 were not appointed. And then after that, another 2 were appointed. Why? Chief Justice Lodha had said at one point of time that don't segregate the names. What is actually being sent is one recommendation. That one recommendation consists of 5 names, consists of 10 names. All right. And there is a reason why the order in which they have been sent. Okay, the order could be seniority, could be whatever. Probably the date of registration as a member of the Bar Council. Now, you disturb that because you segregate. So it's like telling the Collegium of the High Court, listen, we don't care what you think. We will do what we think. And there's nobody to question us. Right? And the Supreme Court Collegium then keeps quiet and says, all right, you're entitled to segregate. No, but they're not entitled to segregate. It's one recommendation. You either accept the recommendation in full, or you defer it in full, or you accept it in full. Don't, piecemeal pick up one person from here, one person from there. It affects the overall seniority of the person. It gives rise to rumors. It gives rise to speculation. Why should that happen?
Also, we have also instances of the names which are reiterated by the Collegium being ignored, being kept pending. Although, as per the judicial precedent, once a name is reiterated, that is binding on the executive. But even such names are also kept pending. We have several such instances.
Yeah, you have instances where the names have been reiterated twice.
Right, right. So should the court, on its judicial side or administrative side, should take a firm stand with respect to such instances? What do you think? Response?
You see, this is where transparency comes in. If the government tells the Supreme Court Collegium that we are returning these names for reconsideration or whatever it is, why are they sending it back? Do we know? Today we don't know. All right, except speculation. I mean, not even speculation, because there's no way to understand why they're not sending the names. I mean, returning the names. So you can't even speculate on that. Now, the Supreme Court then sends it back, reiterates the name. The government sits on it for months together. In some cases, for years together. Why? Are we not entitled to know these things? Is this the way the government wants to treat the Supreme Court of India? We don't care what you recommend. We'll do what we want. Should we tolerate this? Should we accept this? That Supreme Court, you can say whatever you want. We'll do what we want. We don't care for you. I don't think that's fair to the judiciary. I don't think that's fair to the justice delivery system. I don't think that's fair to the institution. I don't think that's fair to the country. That you treat our Supreme Court in this manner. You can't treat the Supreme Court in this manner. Let's be clear about it.
So what should be the response of the court to such instances? That should...
Well, I think the Supreme Court should be tough. And transparency.
For example, recently we had an instance of a person whose name was kept pending. He later withdrew his consent and resumed practice. There are certain cases of a person who, an advocate, he had to wait for 2 years for his recommendation to finally get accepted by the central government.
Yeah. Why is it happening? Don't you think as a citizen?
Right.
Don't you think as a citizen you should know?
Certainly, that's.
Well, there you are.
Right. And you have been serving as a judge of the Supreme Court of Fiji as well as after your retirement. So are there any good practices which our judiciary can adopt from your experiences in the international field as well? Regarding
on the question of appointment?
On the question of appointment.
Yeah. You see, in Fiji, they have something called the National Judicial Service Commission. I don't know whether it's called National or just Judicial Service Commission. But they have a Judicial Service Commission, of which the Chief Justice of Fiji is a member. There are other persons who are members. They deliberate on the names. Right? They pick up persons from wherever they want to. They deliberate on the names and then take a call. All right. Now, as far as I'm concerned, I have been given to understand that my name was recommended by the Chief Justice of Fiji. The Judicial Service Commission made their own inquiries. They took their own time. It's not that they said, yes, we agree. They took their own time. I'm sure they did some kind of a background check, and then they approved it. When my name came up for an extension, again, they took their own time. Now, the Chief Justice had recommended that the proceedings of the Judicial Service Commission should be videographed. Okay. That was not accepted, but he told me that the proceedings are recorded. Okay, so whatever each person says is recorded. It's archived. It's not,
Published.
made public, put on the radio or TV or something, what people have said, but it's archived. And I think that practice is still continuing of recording the deliberations of the, so that later on, if there is some controversy or some such thing, you have a record, Now, we've had controversies,
Right.
whether the, what was the resolution passed? Was a resolution passed? What was the decision taken? Was a decision taken? All right. And now, if there's a recording, you will not have that controversy. That's why this is important. You know the one that I'm referring to.
You're right.
And if there was a recording, everything would have been clear. But now you have, this is not there, that is not there, this is not what happened, that is not what happened. So I would suggest it's a good idea to have a recording, archive it. Don't put it on All India Radio and Doordarshan and all that. That's not necessary. But archive it, so that in case there's a controversy,
So, right, sir. So you would say that there should be a little more transparency with respect to the judicial deliberations. And now we have, the courts have also started live streaming, saying that while accepting live streaming, the court said that a little bit of sunlight is the best disinfectant. So maybe we should have that sunlight with respect to the judicial selection process as well.
Yeah. Right. Yeah. Let me tell you, when I went to Fiji in 2019, 3 years ago, at that time, and probably earlier also, the court proceedings were being recorded. Right. So when I had asked a question to the lawyer, the Chief Justice told me, he said, please speak a little louder. All right, speak into the microphone. So I asked him, I said, why? I mean, the lawyer can hear what I'm saying. Even the litigants who are sitting at the back can hear what I'm saying. Then he told me, he said, no, but everything is being recorded. So unless you speak loud enough or speak into the microphone, the tape recorder will not catch it. So if Fiji could do it at least 3 years ago, and they must have been doing it earlier also, I don't see why we can't. It helps, in the matter of a review petition, for example. What was the argument that was advanced? What was the concession that was made, if any? These things are important, and I'm glad that live streaming is going on. But I hope whatever is being live streamed is also being recorded and kept and archived.
Right, sir. So thank you so much, Justice Lokur, for sharing your views. Thank you so much for.
Yeah, thank you, Manu. Thank you, Manu. Thank you.
Have a good day.
Right. Okay, have a good day.